Hi, my name is Juliet Selgren, and this is my podcast, The Great Antidote. This podcast has been brought to you by the Center for Growth and Opportunity at Utah State University. To learn more, visit www.thecgo.org. Today I have the pleasure of speaking with Clark Neily. He is the Vice President for Criminal Justice at the Cato Institute. His areas of interest include constitutional law, overcriminalization, civil forfeiture, police accountability, and gun rights. Thank you so much, Clark, for joining me on such short notice.
My pleasure. Thanks for having me on.
So, with our nation focused on the horrible events, the horrible death of George Floyd, I figured that it would be a good time to do a special episode specifically on how we got here. So, today I would like to talk to you about different issues that predate this case because sadly, this isn't the first time. There are many, many people, black men in particular, Freddie Gray, Michael Brown, Eric Gardner, only to name a few of so many that have been killed by police violence or they've had their constitutional rights violated in some way. These issues include the role of prosecutors and the police unions in protecting violent police officers from prosecution, along with qualified immunity, which the Supreme Court created in 1982. But before we jump into this kind of more somber topic, I wanted to ask you, what is the most important thing that people my age should know that we don't know?
The most important thing that people your age could know about our criminal justice system is that we actually have two criminal justice systems in America. There's the one that is described and prescribed in the text of the Constitution and mythologized to school children. And then there's the one that we operate in real life to maintain the world's highest rate of incarceration and to operate what I describe as a criminal justice wood chipper. And it is a raging dumpster fire of injustice. And it really is a misnomer to call it our criminal justice system. It's simply a criminal legal system that largely exists to incarcerate the maximum number of people that it can.
Yeah, I mean, I would say that's really important to know. Okay, so about the cell phone video of George Floyd, you've said that it is our civil duty to watch it. Can you explain why you think it's so important that everyone watches it? And having followed your advice and even watching parts of it beforehand, I can say it's truly horrifying.
It is, and I think there's a civic duty to watch that video for a number of reasons. First, because the police in this country purportedly or ostensibly work for us. So what they do in our names, and we have some responsibility as a result. And what I see in that video is a police officer, a public servant, if you will, demonstrating callous disregard for human life. One of the things that scares me about the video more than anything is there's complete lack of emotion on that police officer's face. He doesn't appear to be angry or scared. He's just standing there or kneeling there, systematically squeezing the life out of another human being. And he looks like he could be, teaching his kid how to fish. And the banality of evil that we see depicted in that sequence, I think is important for people to understand that people who work for us and who are ostensibly accountable to us sometimes behave like that. The other reason I think it's important is that there's a tendency on the part of some people in this country, particularly people on the right, to dismiss or diminish the extent to which our criminal justice system reflects pervasive and unjust racial disparities. And that video very vividly and tragically conveys how misguided it is to try to diminish the extent to which our criminal justice system remains in many ways fundamentally racist, and we all have an obligation to make ourselves aware of that fact and to work to change it.
So let's talk about the prosecutors in the system. So, if history is our guide, we know that prosecutors rarely bring criminal charges against police officers. Is it because they have to repeatedly work with them, or because they don't want to piss off the police officers, or are there other reasons?
Yeah, I think that's a large part of it. I think it's largely kind of cultural and institutional. In our country, police and prosecutors work together side by side. Prosecutors depend on police to bring them cases. They depend on police to testify in those cases, and there really develops a kind of an almost familial relationship. For example, it's not uncommon at all to hear prosecutors refer to my police officer when they're talking about a police officer who is going to be a witness in one of their cases. And so think about the mindset that reflects. And of course, another thing to keep in mind is police unions are very powerful in this country. They throw a lot of weight, and that's kind of an implicit threat hanging over the head of any elected prosecutor. Most state and local prosecutors are elected, and you better be on good terms with the police union if you want to get reelected. And one of the number one things you can do to impair or destroy that relationship is to be perceived as being unduly aggressive, which is to say, aggressive at all about bringing criminal charges against police officers. So there's a whole constellation of dynamics that result in prosecutors having a massive conflict of interest when it comes to enforcing criminal laws against police officers, and I think that's basically the reason why it almost never happens.
Hmm. This time around, Minneapolis police officers were brought charges. They were like prosecutors took action, but do you think that the officers would have been charged if the assault had not been captured on viral video, if the protests had not exploded all over the country?
No, I don't think there's the least possibility that the charges would have been brought. Charges are almost never brought against police, no matter how gross their misconduct, unless the conduct is caught on video that goes viral, because only then does the failure to act become a political liability to the prosecutor. But short of that, police are virtually never charged for misconduct that is not, you know, caught on video and publicly shared to the point where the prosecutor feels politically obliged to take action, and it's a real tragedy. I hate to sound cynical, but I'm just describing the truth. And so the answer is no. Those charges would not have been brought but for the publicity.
That's awful. I mean, at least we have technology so we can so we can have videos so people can be brought to justice, but the fact that it's not without struggle is awful. So kind of going back to police unions. Um at Reason, Peter Suderman writes the following. He says that, quote, "This is what police unions do. They defend the narrow interests of police at the expense of public safety. They exist to demand that taxpayers pay for dangerous and even deadly negligence. And although they are not the only pathology that affects American policing, they are a key internal influence on police culture, a locus of resistance to improvements designed to reduce police violence. To stop bad cops and police abuse, we must tackle police unions." End quote. So, can you talk to us about the role that police unions and collective bargaining contracts have played in tragic events like the death of George Floyd?
Yeah, they bear tremendous responsibility for the dysfunction that we see in for incidents like the killing of George Floyd. Probably the most significant problem that they represent is that it is really almost impossible to fire an unfit police officer for a couple of reasons. First, it makes the police union contracts make it very difficult to identify them in the first place. They saddle internal investigators with all kinds of limitations. Police who've been accused of misconduct get all sorts of special benefits that ordinary citizens don't, such as a cooling off period where they don't have to answer questions about an incident until sometimes several days later after they've had an opportunity to confer with counsel and with a union representative. Oftentimes, they're given access to all of the video and other material that depicts what happened so that they can conform their story to the available evidence, which is, of course, another sort of benefit that ordinary people are not given. So that's on the front end. All these police union contracts make it very difficult to identify the unfit officers in the first place. But then, even once you have identified a manifestly unfit officer, the union contract provides all kinds of layers of procedure and review that make it virtually impossible in many cases to fire a police officer who has no business carrying a gun and wearing a badge. And so I think those are the two sort of primary ways in which police unions impair accountability and ensure a higher concentration of unfit police officers than we would otherwise have.
It has also been written about research that shows that, quote, police get paid more, yet the public is no safer. And it's even at greater risk of violence by police, end quote. So, what needs to be done?
A lot of things need to be done. One thing we need to do is to harness the power of incentives. And I mean, particularly economic incentives. Almost everybody responds to economic incentives, and there are all kinds of ways in which we could do a better job of harnessing economic incentives here. And I'll just give you two examples. One idea that I've proposed is to um, eliminate this doctrine called qualified immunity that makes it very difficult to sue police officers for their misconduct. So we enable people to sue police who have arguably violated their rights. The other thing we need to do is to eliminate something called indemnification. This is a policy by which the police department or the city or the state will pay whatever damages are caused. And I'm talking about monetary damages are caused by a police officer's misconduct. So if an individual police officer engages in misconduct and hurts somebody, um, 99.98% of the time, and that's an actual statistic, by the way, 99.98% of the time, the damages are paid not by the police officer who committed the misconduct, but by the city or the department or the state. And that means by us, the taxpayers. That's a ridiculous policy, and we could easily change it. And what we would do is require police to carry professional liability insurance the same way that doctors and lawyers do. And we could even provide them with an allowance to do that, because all we would do is we would take all this money that we're currently paying out in civil damages claims, and we'd redirect some of that money in the form of an allowance to individual officers to purchase liability insurance. And one of the reasons that would be so good, there are really two reasons. First, insurance companies are extraordinarily good at identifying risk. In fact, that's basically their whole business model. So they would immediately begin to develop very useful information about which particular officers are generating the most claims, whether there are particular situations that seem especially problematic, so you could handle those situations differently. Maybe have a supervisor come out to certain interactions, things like that. And then the other thing that it would do is that, just like with a bad driver, a police officer who was generating a lot of claims because he was engaging in a lot of misconduct, his insurance, the cost of his insurance would go up. The cost of his premium would go up, just like it does for a bad driver. And eventually, the worst police officers would become uninsurable and therefore unemployable, and they would have to leave the profession. And that's exactly what we want to see. And it's astonishing that we're not harnessing the power of these kinds of incentives, but we're not. The other thing I would do is I would create what I call a constitutional small claims court. A lot of the misconduct that police engage in is relatively low level, does not involve, the use of lethal force, doesn't result in a serious bodily injury or a death, but it's persistent, it's important, it needs to be addressed, and we don't address it. So, and this kind of picks up on, or it reverses the idea of this broken windows theory of policing. The idea being, if you let little stuff slide, then you're going to get bigger stuff because you're sending a message that you don't really care. Well, I think that dynamic certainly plays out here too. We allow police to get away with all kinds of relatively smaller rights violations, and we need to stop doing that. And one way to stop doing that would be to create a forum, which I call a constitutional small claims court, where people could sue police for relatively smaller rights violations. Like telling you to shut up when they have no authority to do that, or telling you to back away from an arrest that they're performing so that you can't record it, which you have a constitutional right to do, things of that nature. And so, if we would encourage people with relatively small damage awards who experience that kind of police misconduct, then I think we could again harness the power of incentives. And I have a whole built-out proposal for this. But basically, what we would do is provide police with kind of an additional salary benefit, and the damages from this court would be paid out of that benefit. And the fewer damages they cause, the more money they'd get to take home at the end of the year. So again, harnessing the power of economic incentives to produce better police behavior. There are all kinds of things that we could be doing and we're not.
Do you think that like the riots and protests that are happening around the country today will cause some sort of policy change?
Yes, I do. The most significant one that people are talking about, and something I've been working on almost night and day for 2 years, I referred to a moment ago, qualified immunity. Qualified immunity is a legal doctrine that was invented out of whole cloth by the Supreme Court to make it much more difficult to pursue a civil damages remedy in court. So we already talked about how you cannot depend on prosecutors to prosecute police who engage in misconduct. Neither can you count on internal accountability mechanisms like internal affairs or a citizens review board. They're completely ineffective. The only really effective avenue of accountability is the ability of a citizen to sue a police officer in court for civil damages. Unfortunately, the Supreme Court, by inventing out of whole cloth this so-called qualified immunity doctrine, makes that very, very difficult and creates a system whereby police who have demonstrably engaged in misconduct and violated people's rights can nevertheless get cases thrown out of court because qualified immunity requires the plaintiff to identify a pre-existing case in the jurisdiction where some other cop did the exact same thing to someone else and a court said that it was not permissible. If you can't find a case with nearly identical facts, to like identical to what the police officer did to you in this instance, if that case doesn't already exist, you can't sue that police officer, and it's ridiculous. So a lot of people on Congress, just in the last few days, have been taking a stand against qualified immunity. The Supreme Court also has the ability to undo the qualified immunity doctrine, and Cato has played a very prominent, in fact, lead role on both of those fronts. We are leading the effort to get the Supreme Court to dismantle qualified immunity in the judicial branch, and we're also leading the charge to get Congress to dismantle qualified immunity through the legislative branch. They both have the ability to do it, and they should both exercise that power.
Can you give us an example of a case where qualified immunity is at play in basically making it so a police officer doesn't get prosecuted or charged for whatever act?
Yeah, I can. Just one thing that's important to clarify is that qualified immunity is a civil rule only. It doesn't have any application on the criminal side. We already talked about why police are not generally prosecuted, and that's because of the massive conflict of interest that prosecutors have. On the civil side, qualified immunity prevents people from suing police for engaging in misconduct unless they can find a nearly identical case already on point. And I'll give you a real case that's right now pending before the Supreme Court. They haven't decided whether to take the case because that's up to them, but they've been asked to do so. And here's what happened in the case. This is an incident in Georgia where police were pursuing a suspect through a residential neighborhood. They tackled the suspect on the front yard of a home where a bunch of children and some adults were outside, and they made everybody lie down on the ground so they could secure the scene. And once the officer who had tackled the suspect had him handcuffed, in the middle of all that, after he'd gotten the handcuffs on, the family dog came out from underneath the house. He wasn't growling or barking or threatening or anything like that, but nevertheless, the police officer pulled out his pistol and took a shot at the dog. He missed. The dog went back under the house. A few minutes later, he came out again not threatening or barking. And the police officer drew his pistol again and shot at the dog, and he again missed, but this time he struck a 10-year-old boy who was lying on the ground a foot and a half away from the police officer. He hit him in the back of the leg and gravely injured him. The family sued for the misuse of force, and the court applied qualified immunity and threw the case out. Why? Because there wasn't another case already in that jurisdiction with nearly identical facts. That is how the qualified immunity doctrine works, and it's every bit as perverse as I just described.
That's awful.
It is
It's
awful.
just completely awful. In a recent article, you wrote about qualified immunity that, quote, there is no credible textual or historical basis for the qualified immunity doctrine. It is a blatant act of pro government judicial policymaking, activism, if you will, and nothing more. End quote. So, was the intent of the Supreme Court to shield police officers, or is that an unintended consequence of the ruling? Or is it a consequence of the way that the rule has been interpreted by judges?
Yeah, I think it's all of those things. It's. I think the whole constellation of kind of pathology here is somewhat complex. I do think we can say that it qualified immunity seems to have started out with a somewhat reasonable, kind of mindset, and that is that originally was quite limited, and its only role was to ensure that a police officer would not get sued if they were enforcing a law that at the time was valid. It hadn't been struck down, it hadn't been called into question, and only later was the law struck down. And the idea is, well, if the police officer was enforcing what seemed like a valid law at the time, and then we didn't even find out that it was unconstitutional until later on down the road, then it wouldn't be fair to allow that police officer to be sued for enforcing the law at a time when everybody thought it was constitutional. That's not actually the statute that Congress wrote. Congress wrote a statute that said that a state actor like a police officer shall be liable to the person injured for the deprivation of any rights. It's a strict liability standard, but I think it's not an unreasonable, gloss to say, well, listen, I mean, if the law that you were enforcing was at the time perceived to be valid, let's give you a pass. Unfortunately, what happened is that they started from that kind of little kernel of reasonableness, and they just kept expanding and expanding and expanding and making the doctrine more and more and more pro-government, which is kind of a thing with the Supreme Court. It's basically it's kind of their jam to just make things more and more pro-government. And they certainly did that with qualified immunity, and now it's just this grotesque caricature of what it started out as. And now it really is nothing more than just a get out of responsibility free card for police officers. And I think it's had a huge role in undermining public confidence in law enforcement. I think it systematically infantilizes police. It lets them off the hook for things that anybody would know is wrong and you're not supposed to do. And that if any one of us did it, we'd be in a lot of trouble. But if you wear a badge, then qualified immunity is going to take you off the hook. And I think that's absolutely wrong. And I think we're seeing the consequences of that in the anger and the frustration and frankly the rage that we're seeing. I think all of that is absolutely well founded, and the Supreme Court bears significant responsibility, in my judgment, for creating this doctrine that has really created a double standard between ordinary citizens and police. I think the Supreme Court doesn't realize that people perceive that double standard, or at least they didn't up until now, but they're getting a lot of information very quickly, I think, about what they've done.
So, as a recap, when someone's right is violated by the police in any way, prosecutors don't prosecute, but on top of that, the victims can't sue in a civil court. So, do we have any sort of recourse against police abuses?
No, not really. Uh, Again, the only really three avenues are first criminal prosecution, and we discussed why that is ineffective because of the massive conflict of interest the prosecutors have and the sort of institutional predisposition they have to turn a blind eye to police misconduct. We have internal accountability mechanisms, but they don't provide any real accountability. They're just window dressing. And then third and finally, we have civil damages lawsuits, and the Supreme Court has basically kind of gutted the ability of people to do that, and there's really nothing left. There's no real political accountability. There's no other form of accountability, and police perceive correctly, I think, that they can get away with just about anything, and unfortunately, all too often they do. And I want to emphasize something that bears emphasis. It's communities of color that bear the brunt of police misconduct, and it's a shame, and we should be ashamed. Those of us who do not bear the brunt of those acts of misconduct that we have stood by and done so little for so long. I hope that's changing now. It needs to change, and we all bear some responsibility to ensure that it does.
I hope it changes. Um, this week, specifically, there are 8 different qualified immunity petitions before the Supreme Court, and you mentioned one of them. So that includes 3 cases calling explicitly for the court to reconsider the doctrine for qualified immunity. Can you explain how that works and what's happened?
Yes. So basically, what happens when you bring a lawsuit against a police officer or other government official, if they assert the defense of qualified immunity and the court grants qualified immunity, in other words, they'll dismiss the case on qualified immunity grounds, you can appeal that decision. And that's what's happened basically is that people have appealed cases where they've lost or they've been thrown out of court because of qualified immunity. They've appealed that up through the system. And a number of those cases have reached the Supreme Court over the past year or so. And there's some very high quality cases involving some very compelling facts being handled by some excellent lawyers. And what has happened basically is that the Supreme Court has kind of handled these cases procedurally in such a way that they've all stacked up. And the court has sort of delayed making a decision about whether to accept these cases to review. It's important to keep in mind the Supreme Court only takes a very tiny fraction of all the cases that are presented to it every year. It gets about 10,000 applications to review cases, and we lawyers call those cert petitions. They get about 10,000 cert petitions a year, and they accept only about 60 or 65 cases. A number, more than a dozen very high quality qualified immunity cert petitions piled up over the past year. And they've disposed of a handful of them in various ways, but there are still 8 remaining that provide the Supreme Court with the opportunity to not only grant review in a case involving qualified immunity, but a number of those cases explicitly ask for the court to revisit the entire doctrine and reverse the cases that created it and eliminate qualified immunity. And as I said before, Cato Institute, where I work, is the leading organization in coordinating those efforts, in promoting those efforts, and in trying to convince the Supreme Court to do precisely what I just said, which is to grant review in one of these qualified immunity cases and use that as a vehicle to reverse the cases that created qualified immunity and eliminate that doctrine judicially. The Supreme Court has the power to do that, and they should do it.
Is there any reason why the court would not address it today, especially since this country is kind of going up in flames with riots and protests and stuff?
Yes, unfortunately, a couple of reasons. First, the Supreme Court tends to be quite reluctant to revisit precedents. That means cases that have already decided a particular issue, otherwise known as stare decisis. As an institution, the court tends to be quite conservative, not politically conservative, although some of the justices are, but I mean just conservative institutionally. They don't like to take big steps, and one of the steps they especially don't like to take is to overturn existing precedent. So that's one thing that would potentially prevent them from doing that or cause them to make a decision not to do it. The other is that the Supreme Court tends to be a highly pro-government institution. A lot of people don't realize that because we tend to see the Supreme Court, when they're striking down laws that impair speech or free exercise of religion or whatever. But that's actually extraordinarily rare and a very, very small part of the Supreme Court's work. The biggest part of the Supreme Court's work by far is rubber stamping lower court rulings that rule in favor of the government and issuing decisions that affirm government power and help expand government power. You wouldn't necessarily know that if you just focused on the sort of the high profile, free speech cases and so forth. But really, the Supreme Court institutionally is not just sort of conservative in the way that I described, meaning they don't like to take big steps and they don't like to revisit old precedents, but also very pro-government, very, very government-leaning, and very inclined to affirm what the government is doing to help expand government power. And I've actually written a whole book about that called Terms of Engagement, how our courts should enforce the Constitution's promise of limited government. And I provide a more extended explanation and defense of that basic thesis that fundamentally the U.S. Supreme Court is a government favoring and government empowering institution. And certainly qualified immunity is a prerogative that government officials highly prefer because it lets them off the hook and gives them immunity from citizen lawsuits. So I'm hopeful, but institutionally, it's certainly more the predisposition of the Supreme Court to kick issues like this down the road and not address them.
I definitely will be reading your book because I don't know, this is a topic I'm really interested in, is the way that the courts work, the way Supreme Court works and stuff. And the fact that it's not guaranteeing, it's not ensuring what was promised is kind of alarming. So, to conclude, do you have anything? Well, to conclude before my final question, do you have anything to add to this topic that we haven't talked about that would be key in understanding or just in addition?
I do. I want to end on a note of hope. Although I have deep concerns about some of the institutions that we've discussed, including law enforcement and the judiciary, they're not wholly unresponsive. And they absolutely recognize, and when I say they, I mean the law enforcement community and I think the judiciary and also the legislative branch, they really recognize how outraged people are. And I think they also recognize that people are legitimately outraged about not only what happened to George Floyd, but also the overall kind of framework that exists that kind of not only permits things like that to happen, but basically ensures that they will. One of the most heartening things I saw in response to these events was police departments all over the country, including Arlington County, where I am. I got an email from Arlington County with a statement from the chief of police condemning the behavior of the police officers in Minneapolis who killed Mr. Floyd, and affirming that they are not going to conduct themselves like that, and they will be respectful of people's rights. Um, I don't necessarily think that always translates into action, but it's quite significant. I think even just purely symbolically that they feel moved to issue those assurances, and we are seeing movement. I've been talking all week, and I'll talk all week next week with members of Congress about these issues, and I'm getting a sense of seriousness and commitment that I've never felt before. So, I think there's real reason to hope that this will be an inflection point, and that the tragedy in Minneapolis may ultimately prompt some meaningful reform. And obviously, that won't bring George Floyd back to life, or probably provide much comfort to his family. But in some small way, maybe it will help to redeem his senseless death.
Yeah, I mean, that's at least police are taking steps, and at least there are people like you who are going out and fighting in Congress, just everywhere for a change, you know? So, final question: what is one thing you believed at one time in your life that you later changed your position on, and why?
I used to think that if you were going to be charged with a crime somewhere in the world, that you would want to be charged with that crime in America, because we have, sort of procedurally the most reliable and fair criminal justice system in the world. I no longer believe that. We do have on paper um, the best or among the best criminal justice systems in the world. But as I mentioned at the beginning of our discussion, it's all window dressing at this point, or nearly all window dressing. And the way our criminal justice system actually operates has very little to do with appearances or what is described in the text of the Constitution. What we have is much more accurately described as a conviction machine. It operates very efficiently, and police, prosecutors, and judges have discovered all kinds of ways to fundamentally hack the system, so that from the point at which you are accused by a police officer or a prosecutor of having committed a crime, the likelihood that you will ultimately be coerced into pleading guilty, whether you are or not, is close to 100%. And that's the reality of our criminal justice system. And I would prefer to be prosecuted in the criminal justice system of many, many other countries than ours, because I know how ours works, and I know what kind of power prosecutors have to coerce a guilty plea, whether it's has any basis or not. And I know that judges will systematically turn a blind eye to all of that, and it's terrifying.
That is terrifying. Well, thank you so much for this. I am honored. I learned so much, and I hope my listeners learned so much, learned a lot as well, because this is a very important topic, and I think this is an important aspect of what's going on right now in our country. And I think this is a turning point, or could be a very important turning point for our country. So thank you so much.
My pleasure. Thanks so much for having me on.
Yeah, of course.